How long does a landlord have to repair a reported maintenance issue? This maintenance is one of the most important things that I'd say to you at the moment, not only under this Act, not only under HHSRS, but also under deregulation and service of notice, Section 21 and Section 8, okay? Maintenance is a really, really important factor in the management of a tenancy. Now, they haven't given us good guidelines. They've just said you must repair the reported hazard or maintenance issue in a reasonable timescale. So you have to then use common sense as to what is reasonable. For example, a tenant reported a problem with the boiler. There's no hot water and heating, okay? That's quite an emergency. Hot water and heating is a standard requirement. But landlord got a contractor out same day. Contractor assessed the situation. Parts were needed. They weren't going to be there for something like 8-9 days. Tenant was going to be without hot water and heating for 8-9 days. Has the landlord done everything he can? Yes. Has he acted in a reasonable manner? Yes. The landlord has done what he can. The tenant is obviously not happy because they're without hot water and heating for 9 days. I understand. But if they owned that property, what could they do different? What could they do different than what you have? Now, if you as a landlord dragged your feet and didn't do that, and you didn't send out a contractor straight away, and you did just leave them there, and you wanted 16 quotes for a new boiler before you decided to choose one, that wouldn't be reasonable. Does it make sense? So common sense is what we need to look at.
Could they be expected to provide electric heaters?
Heaters, yes, depending on the temperature outside. If it's in the summer and the temperature is at a certain level, then no. If the temperature is below a certain level, then yes.
The problem I have is if anything goes wrong, and the gas say to them, the calling time will be between 6 and 6 o'clock at night, and they turn around to me and they say, I'm working. I said, what the hell am I doing?
That's not your problem.
That ain't my problem.
It's not your problem. You have given them reasonable timescales in line with, because reasonable timescales are within working hours. Tenant has to allow you reasonable access to repair. They cannot expect contractors to work at 8 o'clock at night, Saturdays, Sundays. Reasonable is within working hours, and they have to allow access. It's their problem. They have to allow the access. It's not.
If I give them the time that they're going to court, that's up to them.
That's up to them. And if they fail to turn up, you document that. I sent a contractor at this time, and you chose not to allow the access. I had a right battle with a tenant once about a washing machine delivery on a Saturday. Landlord had to pay an extra £35 for delivery on a Saturday, and I said to the tenant, unfortunately, the landlord's not prepared to do that because he's already buying you a replacement washing machine, he's fulfilled his obligations, and we battled for absolutely ages. But why should the landlord pay an extra £35? You know, at the end of the day, as tenants, they also owe you obligations under the tenancy agreement. And under Warren v Keane 1953, the tenants must act in a tenant-like manner. And they must do reasonable jobs within the house, like changing washers on a tap, repressurising the boiler, changing light bulbs. They must do reasonable jobs that they are capable of doing. It shouldn't be your problem. So, yeah, absolutely, you'll be fine. Yes, go on, Andy.
There's a second one down on the HMOs.
Mm-hmm.
What's your guidelines on landlords or agents going into the common areas of an HMO without notice?
My guidelines is that you don't need to give notice if the tenancy is only on the room because you're not infringing their dwelling. If you give a tenancy that includes the shared area in any way, then you should therefore give them notice. But, for example, when we give a tenancy on a HMO, it's on room 1. It's not on room 1 and the rest of the house. So we are able to access the common parts if needed without notice. Best practice is notifying them, but it's not always possible. So, no, I don't think you need to. But if you do notice... So a landlord is responsible under this Act in particular the minute you are aware of the hazard, OK, the moment that you realise. Any hazard, however, located in communal parts or blocks of flats or houses of multiple occupancy, you're immediately liable. The reason for that is because there's a higher risk of danger to others, not just your tenant with inside your property. HMOs in general just have higher legislation requirements. You have a reasonable time to remedy the hazard, and it's important that you carry out all maintenance that you are legally responsible for. And if it's something that you're not, as I've said, in a communal area, that you notify the people that are. Now, I will say to all of the landlords in this room, a landlord doesn't want to do maintenance the most when a tenant is not paying rent. I understand it completely, but it's actually the most important time for you to carry out the maintenance. Failure to repair under your obligations when a tenant is in arrears will give the tenant a defence in court when you are applying for possession, and it will likely hinder your case. So I know and I appreciate the frustrations that if they are in arrears, why should you fix the bloody property? But please do. And also, we have some landlords that just say, no, I'm not fixing that. I'm sorry, I can't afford to. I'm really sorry, but you've got a legal obligation to, and I understand sometimes you might not be able to afford to, but you have to find the money to carry out your legal obligation, your legal obligational repairs. You just have to. Because otherwise the tenant can sue you for not doing so. And unfortunately our courts always favour tenants, or 90% of the time favour tenants. Access, we just talked about. A landlord should ideally provide 24 hours notice for a contractor to attend, shorter if it's an emergency. There are a few different things that you could look at here, which would be sometimes we might need to act as agent of necessity. You might need to act as landlord of necessity. If you notice that there's water gushing through the centre of your property, you're going to have to get in now without giving the tenants any notice. If the property is not secure in any way, you're going to need to secure the property with little notice. But it is really only in the case of emergencies that you want to, you want to be lowering that 24-hour access. Now, if you write to a tenant and tell them, for example, gas certs, if you've got a gas cert that's outstanding, tenant won't let you in, and you write to them to say we're coming in with spare keys to do it on X date, as long as you've given them 24 hours notice, that is fine. However, if the tenant then responds to your letter and says, you ain't coming in, you must not go in. Your letter doesn't give you the automatic right to go in if they decline it. No. You have to put in within the letter, if this is not acceptable to you for any reason, please let us know. And if they do let you know, you can't go in.
So when do you get in then?
You can't.
Oh, that's good.
So can they just repeatedly deny you access?
Yes.
And there's no point in which you can...
There is, you would start to take them to court for breach of tenancy, but discretionary grounds on the Section 8, it's very complicated. But if they are that problematic, they're probably in arrears and you'd be looking at serving them notice anyway and going down that route. What I would say is if they don't give you access and there's repairs outstanding or gas certs outstanding, don't give up. Keep trying, obviously not every day, but document every attempt that you make to do so. So if you manage the property yourself and they're not letting you in to do a gas cert, you must document every attempt that you've made, every letter that you've sent, every step that you've taken, so that you can prove if it does go to court, I have tried everything that I am legally allowed to do to carry out the gas certificate on this property. Yeah, because you will need that as a defence. Yes?
So obviously there's a difference between asking someone if you can access and then saying we will be accessing if you object to let us know. Is there any particular approach that should be taken as opposed to the other?
Well, first and foremost, you would always ask, hi, your gas cert's due, you all right? What date can we book that in? If you can't get hold of your tenant and the tenant's not booking, we write to the tenant to say, gas cert's due, can you contact the engineer or whatever? If you're having trouble getting hold of the tenant and getting the access, then I would go down the written letter route. Just to let you know that the gas safety certificate is now overdue or due for expiry, and to enable to protect the landlord and yourself under the gas regulations 1998, we do require access, and our contractor will be attending on this date at this time for your safety. Please let us know if this is not suitable. You don't need to be present. At that point, if they say you can't come in though, you must not go in.
But if they don't respond at all?
If they don't respond, then that's fine.
So unless you've got a good relationship with your tenants, it's bloody awkward, isn't it?
It is. And, you know, we manage a large amount of properties and quite often we get these difficulties. They are normally with the problem tenants, like I say, if they're not paying the rent or whatever the case may be, because most tenants would let you in to do the gas cert because they want you to be safe. But an example of one we had the other day, gas engineer actually did gain access, or somebody gained access, and the tenants, no, they didn't. Something else had happened. But anyway, tenants had bypassed the gas and electric meter. So couldn't do the gas cert, and in fact what the gas engineer did was capped it off, turned it off. So they now have no gas. is landlord responsible for solving that problem? Absolutely bloody not. The tenants have bypassed the gas meter. He has no obligation to repair that problem. What we actually had an obligation to do was report them to the supplier. It's illegal. But now they're without gas. Yeah?
In the event of a business, who pays the gas certificate on that? Is it still the landlord or is it the business?
In the event of a company, you mean?
Well,
It's
I rent, we've got a commercial property,
okay.
and I paid it last year, but do I still have to?
It will all depend on what your commercial lease states. For example, we have a commercial lease on the business that the buildings that we are based in, and we have a full repairing obligation. So we, as tenants, have a full repairing obligation lease. So we have to do the gas cert, the electric cert, the pack testing, any minor repairs. They only have responsibility for major structural repairs. So it will determine on your
I
lease.
think it's the same.
Well, then it's their responsibility then.
Yeah, well,
Yeah.
I got the gas engineer there, I did it.
Yeah. Penalties, as I've said, the tenant can sue you for compensation. Oh, yes?
Yeah, sorry, I should have asked.
It's okay.
If they bypass the meter, is that not grounds for eviction?
There's actually no grounds for immediate eviction in the private rented sector. And I say that apart from the Immigration Act. The Immigration Act is the only piece of legislation that allows you to evict a tenant without the need for going to court. So remember, we've been talking today that the court wait is 3 months. It could be a reason for eviction, but that's how long the process will take you. Penalties are compensation by way of damages through the courts and also an improvement notice which can be issued.